Good morning, everyone. Welcome to the SAICA 2012 Training Regulations Update. In general, over the whole Training Regulations 2012, SAICA has basically just increased their powers. They've given themselves a little bit more clout in writing. They've updated everything for the training contract management system, which is their electronic training contract registration system, not to be confused with our ProBeta assessment tool. They've basically reorganized the regulations and did a whole lot of cleanup, and they've given us some really nice annexures at the end. The structure of the training regulations is Chapter 1 to Chapter 8, which we'll go through briefly, and I will go through the annexures at the end. You do not have these slides, but I will be happy to send them to you at a later stage. But they are exactly the training regulations that you can download from SAICA's website. If you do need them, you can either email Janus or myself or info@ProBeta. Let's begin. The new definitions that they've added in is the training contract management system, just to explain to you what it is and how it works. The definitions for elective, residual, and compulsory skills, which I would hope all of you know, that relates to the new CA training program. It used to be called the CA 2010 training program, effective 2010, but now it's just referred to as the CA training program. The pre-accreditation visit is the site visit that SAICA does before they accredit a training office, not to be confused with the re-accreditation visit. They've set all these outcomes out in Annexure 2. A registered assessor is a CASA, registered as an assessor with SAICA. Please remember that as an assessor, you have a maximum of 15 trainees allowed to be allocated to you. The training, the core hours and the work attendance hours, we will go through in a second. The core hours, they've just made a little bit more simpler to say all the time spent on the prescribed compulsory, elective, and residuals. They do have a list, obviously, in the front of your A&A or your TSR, and that's the list for your core experience hours. Your work attendance hours is all the hours at work, and it is defined in your employment contract. Chapter 2 starts with accreditation as a training office. This basically has been reorganized. Number 4, your requirements for accreditation as a training office. It's just introduced the concept of a group training office versus a standalone training office to bring into account the training officer for the group, which we'll talk about later. Number 5, also not really changed. The only thing that has changed is if you don't have trainees for more than 12 months, it used to be 24, then automatic lapse of accreditation happens. You can always reapply later if you do decide to take on trainees. They've also brought in that TRACO may cancel, the Training Requirements Committee, may cancel your accreditation if you're not complying with training regulations, any of the accreditation criteria, or any of the site visit requirements. Number 6 has had no change, misrepresentation about accreditation, but basically they've said if you are misrepresenting to your trainees, you will be referred to the SAICA and the URBA disciplinary committees, if applicable. Chapter 3 covers the training officer. Number 7, the registration requirements. Also not substantially changed, except that they brought in the concept of the group training officer. And as far as I know, there is only one group training officer at this stage. They must be situated and employed, the training officer themselves have to be situated and permanently employed by the office. It, as in the old days, has to be a CA, SA, a registered assessor, and if they have chosen accounting and assurance as an elective, or if they're accredited for accounting and assurance, they of course must be a CA, an RA, a registered auditor. Now, I did skip full supportive management on purpose. I wanted to talk about that. In the old days, the training officer had to be a partner. That is no longer a requirement. It can be anyone who is a CASA, a registered assessor, and or RA, but they must be able to have access to management and have their full support. So basically to have a little bit of clout. Number 8, the duties of the training officer used to be in the training contract itself. It's now included in Annexure 7. And they're basically saying if your training officer doesn't come to the party or comply with his duties, the office may be deaccredited. And that leads to number 9, which is also not new, to say that all management is responsible for the duty of the training officer. So if you see that the training officer is not doing their duties, you're all jointly responsible, and you may replace him to avoid your office being deaccredited. Number 10, the liability of fees, also not new. Basically, a lot of people have been putting in their training contracts that the trainee is required to reimburse anything that the training office is paying out. The only thing according to SAICA, of course you can basically do what you need to do, but the only thing according to SAICA is that you can require the trainee to reimburse only the fees paid to SAICA. Now, I suppose it would be fair to also ask them to reimburse the URBA fees if they leave within the first year. But please remember that you are a training office, and you do incur certain fees. Number 11, the duties of the trainee accountant, again, used to be in the training contract, now is in Annexure 7. Not substantially changed, really only that the duties or failure to perform his duties may constitute an offence and will be referred to the PCC, the Professional Conduct Committee. The hours of work also have not really changed, just that the prescribed 7.5 hours a day has really just been changed to sufficient work hours. If you're going to hit enough hours to cover your core and work experience, then it doesn't really matter if you work 7.5 hours a day. I must just reiterate that it's impossible, or the chances will be very slim for the trainee to obtain their core and work attendance hours if they're only working half day or 3 days a week. They've also just reiterated that SAICA cannot tell you how much overtime to work, and that it must be in terms of legislation and obviously not illegal in terms of your employment contract. Number 13 and 14 have not changed either, but I just wanted to revise. Conditions of employment cannot conflict to the SAICA regulations. The contract itself, if it does conflict, the SAICA regulations will prevail. You are not allowed to include the QE for academic progress. As per SAICA, again, you decide what you need to do. And SAICA has no jurisdiction. Again, they're just reiterating to the trainees specifically that they've got no jurisdiction on employment contracts. The trainee exit questionnaire has been there for a while, but just so you know, you cannot continue on TCMS if the trainee does not complete the exit questionnaire. It's really just a survey to find out why they're cancelling or how happy they were on discharge. It cannot prevent them from being discharged. Chapter 5, the actual training contract. 15, 16, and 17, again, there's no change. If I can just reiterate again, your entry requirements for a trainee, there must be an employment contract, and there must be a registration with an accredited university for an accredited degree. The 10-month deadline has changed, where you are allowed to register if you haven't yet registered, perhaps in the middle of a year and you're waiting to register the next year for whatever reason. The trainee must prove their registration within 10 months of their beginning of their training contract. Thereafter, you will need to cancel if they are not studying anymore. The probation period, some of us do 3 months, some of us do 6 months. The maximum is 6 months. The training contract will be backdated to the beginning of the probation period if you decide to keep them on a training contract. And the good news is that Section 12H tax allowance from SARS no longer distinguishes between previously employed and previously unemployed. So the probation period doesn't really make a difference on that. The terms and hours of the training contract are set out nicely in a table, 3, 4, 5 years, but the 3 years hasn't changed as the others also haven't changed. But for example, the 3 years is the work attendance 4,500 and the core 3,600 hours. 18, 19, 21 and 24 have cosmetic changes, and they've just basically brought in TCMS. The registration and lodgement, they've just brought in the requirements for TCMS, and that your contract must be registered within 7 months of the beginning of the training contract. They've taken into account the 6-month probation. The remission in the term of the contract, again, they've brought in cosmetic changes for TCMS. Remember that you can get academic remission and RPL remission. RPL for previous contracts and or previous experience. Please, I'm just reminding you that you must apply for RPL within your first 12 months of your training contract. I'd hate for you to miss that. 19.5 is new, where on a 4-year contract, they're basically saying if you get your degree, you are guaranteed a reduction of 12 months. 19.7, there was a loophole previously, I don't know how that went through, where you can only get academic remission once. They've basically blocked that loophole. 20, secondment. This is also not new, but just to remind you that if you do second a trainee locally, it is unlimited. Whether it's to a training office or not, you still remain responsible as a training officer. They must still be your permanent employee, and it must be relevant to getting their core experience. Please don't send them off to collect rent in someone's basement. The limited section is outside South Africa. Again, there's also a table there to maybe your branch outside South Africa. It must be a training office, and it's limited for a 3-year, 4-year, 5-year contract, 180, 240, and 300 days. It is both the training officer and the trainee's responsibility to watch those periods, those maximums. The suspension, also not new. You can suspend for full-time study, anything between 2 to 12 months. If it's less than 2 months, SAICA doesn't want to know. It cannot be more than 12 months, and it must be towards a degree, a bridging course, or CTA. The old items still apply, maternity, etc., and that both of you have to agree to go back to the training office. And the good thing is that you can only suspend once for studies. You cannot keep getting your trainee applying for studying suspension. 22, it's been significantly reorganized. They've included a letter of warning, which is quite nice. I'll take you through that later. And a lot of subheadings for readability. It's much easier to read. In general, though, you can cancel the trainee's contract when the trainee is not studying, if they fail to sit for an exam, if they don't prove their enrollment within 10 months, if they fail to come back from leave, if they're absent, dismissed, incapacitated, or deceased. For academic progress, basically, you will issue a letter within 30 days of receiving their results. You can cancel, extend, and give them that discretionary year, and thereafter, you must cancel unless it's within 6 months of the end and they haven't achieved their hours or their competencies, and that falls under a separate section in the training regulations. The letter is to basically advise the trainee which option the training officer has exercised. This is in Annex 9. SAICA can also allocate disciplinary cancellation, which you will be defaulted 6, 8, or 10 months. Cancellations with no penalty is the old transfer. They've included when the trainee can't commute, where he transfers between branches of an accredited training office, if the company's been de-accredited, if it's been liquidated, and they've brought in retrenchment, which for me is quite sad, but I suppose it's an indication of our times. And then the admin is as usual, also not new. You must bring in or advise SAICA of the cancellation within 30 days of that cancellation happening. Please remember, and this is something that SAICA checks on the training contracts, training visits, the termination of an employment contract should automatically terminate the training contract, but it is not necessarily true vice versa. The extensions, they've brought in the additional 6 months. What happened in the past is we extended them by 6 months, either because we didn't think they'd get their core and work attendance, or if they were not competent, and then we didn't know what to do after that. Now they've brought in the additional 6 months. if you extend the first time and you're not sure that they will be still, you can extend or cancel. And if by the end of that 6 months, if they're not yet competent, then you must cancel. And also they've brought in a bit of clout for the assessment forms that you can extend them, basically penalize them by 6 months if they don't bring in the assessment forms on time. The discharge, also cosmetic changes for TCMS. The big thing is that they've taken out that ethics program. The trainee will be assessed at the ANA level on business ethics. They don't need an additional training program. It is still available if they need it, and there's a whole lot of ethics program that the trainee can attend, but it's not necessary to the discharge. They've just set out what is completed versus what is discharged. Completed maybe without their degree that the training office will sign, and SAICA can only discharge once the trainee achieves their degree, and then the training office exit questionnaire, which is also not new. Please, I just want to remind you that although the training office is allowed to apply and be accredited for 5 electives, which to me is impossible, but that's the rule, the trainee can also have up to a maximum of 3 electives. Number 26, failure to achieve competence. They've just basically improved the clarity, and they've said if 6 months before the end, basically you're doing your ANA, you need to notify them if you find that they're not going to be competent by the end. And that's that letter in Annexure 10, which tells you, the training officer, that you've got to list the competencies that they're not yet going to achieve, some sort of plan on how to get them competent, and that if they fail to do this, it will lead to an extension. Number 27, the assessment of trainees' competence. Mostly the same. Failure by the trainee to initiate the assessment form within the time frame. The old version said will be extended by 6 months. Now they're saying you may extend it. They're just giving you a bit of clout for the assessments. And they've brought in that if the office fails, if the trainee is doing what they need to do, but the officer gets stuck at partner or manager level, the office may be de-accredited and the officer may be put up for disciplinary action. Chapter 7, dispute resolution. There's a lot of cosmetic changes for TCMS. In 28, they list the documents that SAICA is willing to issue. It's not now automatic anymore. 29, they set out disputes and appeals. It's basically been reworked by a lawyer to bring in all the legalese, just to be clear for us normal people, and that you can refer, you or the trainee or the training officer can refer anything to SAICA for arbitration, and that whole process, costs and procedures is set out in Annexure 4. If you're still not happy with that, you can refer anything to TRACO, but then TRACO's decision is binding. It cannot go on and on. Number 30, the disciplinary procedures or the disciplinary process. They're saying covers SAICA's constitution, bylaws, and code of professional conduct. Applies to both the trainee and the training officer and can be applied by either of those parties, and it lists the committees and possible outcomes. Number 8 is just a whole lot of legal things, taking over the 2010 regulations, the 2011 regulations, and any changes basically are binding. Annexure 1, accredited academic qualifications, just says please refer to the website so that everything is always updated. Annexure 2, accreditation criteria, lists everything so you know what SAICA is going to check when they come to accredit you or revisit you, and it basically sets out the stuff for the AMS committee. Annexure 3, complaints, procedures, and referrals. There's a whole lot of requirements, for example, in writing to SAICA. You can read that in your own time. Annexure 4, arbitration process. It gives you all the procedures in detail. Annexure 5, RPL is old, few cosmetic changes. Annexure 6, also old, rules for academic training program. Annexure 7 sets out the duties of the training officer and the trainee accountant. This is a new annexure, but again, as I mentioned earlier, it's similar to the old contract. They've taken out the 7.5 hours, and just to remind the trainees that this is where they comply with timesheets and assessment forms. Annexure 8 is brand new. They've rewritten the whole thing guideline for academic progress. It's really nice, and it's got some nice examples set out step by step, taking into account 100 UNISA modules and BCTA and 2 CTA and all those things. Annexure 9 and 10 are both new. It's your templates for the letters for either contravening academic progress or failure to achieve competence. Just to warn the trainee, just remember that if next year you fail, we may cancel or extend. Now, failure by the training officer to issue Annexure 9 and Annexure 10 does not constitute does not override the rules. So basically it's still effective, the academic progress rule is still effective whether you get a letter or not. But SAICA's reminding you to please remind the trainee of this. I'm sure they're well aware.